Good day, everyone. First question. As evidence, these are those addressed to the senses of the court. When this is relevant to the fact in issue, it may be exhibited to, examined, or viewed by the court. The answer is object evidence. Second question. This consists of writing or any material containing letters, words, numbers, figures, symbols, or other modes of written expression offered as proof of their contents. The answer is documentary evidence. Third question. If the document is in the custody or under the control of adverse party, he must have blank to produce it. If after such notice and after satisfactory proof of its existence, he fails to produce the document, secondary evidence may be presented as in the case of its loss. The answer is reasonable notice. Let me read it again. If the document is in the custody or under the control of adverse party, he must have reasonable notice to produce it. Fourth question. Number 4. When the original or document is in the custody of public officer or is recorded in a public office, its content may be proved by, the answer is, it can be proved by a certified copy issued by the public officer in custody thereof. Fifth question. Religious or political belief, interest in the outcome of the case, or conviction of a crime, unless otherwise provided by law, shall not be ground for disqualification of a witness. This statement is true or false? This statement is true. The answer is true. Number 6 or sixth question. During their marriage, neither the husband nor the wife for for or against the other without the consent of the affected spouse, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other, or the latter's direct descendants or ascendants. The answer is, this is what we call disqualification by reason of marriage. Seventh question. The husband or the wife during or after the marriage cannot be examined without the consent of the other as to any communication received in confidence by one from the other during the marriage, except in a civil case by one against the other, or in a criminal case for a crime committed by one against the other, or the latter's direct descendants or ascendants. This is what we call privileged communication between husband and wife. Number 8. Eighth question. An attorney cannot, without the consent of his client, be examined as to any communication made by the client to him, or his advice given thereon in the course of or with a view to professional employment, nor can attorney's secretary, stenographer, or clerk be examined without the consent of the client and his employer concerning any fact, the knowledge of which has been acquired in such capacity. The answer is privileged communication between attorney and client. This is what we call privileged communication between attorney and client. Ninth question. A person authorized to practice medicine, surgery, or in a civil case without the consent of the patient be examined as to any advice or treatment given by him or any information which he may have acquired in attending such patient in a professional capacity, which information was necessary to enable him to act in capacity and which would blacken the reputation of the patient. The answer is privileged communication between doctor and patient. Last number, a minister or priest cannot, without the consent of the person making the confession, be examined as to any confession made to or any advice given by him in his professional character in the course of discipline enjoined by the church to which the minister or priest belongs. This is called privileged communication between priest and patient. Thank you so much.